This CLE panel originated as a tongue-in-cheek idea. Why don't we have a nightmares Halloween themed presentation on Friday, October the 13th? And as you can see, we love a theme.
We do indeed. Anyone who is a securities lawyer, has practiced securities law, or perhaps knows a security lawyer in your world, has heard some of these nightmares. This is the law practice equivalent to the nightmares you have in college about missing an exam, about forgetting to submit your paper. On the securities side, I think many of us have woken up in a cold sweat in the middle of the night thinking that we'd forgotten an 8K for something that in fact only happened in the dream that we just had. I've been there. Others of us have, filed that filing at 5:27 on the deadline, and you're refreshing Edgar, waiting, hoping it's going to hit. These are the things we worry about, we lose sleep about, and this is what we're talking about today.
So I think one of the scariest nightmares is a mistake that you can imagine yourself or a member of your team making, even though all of you have the best intentions. So this presentation isn't honed in on Ponzi schemes, fraud, diabolical insider trading, although those are nightmares in themselves. It's more just the regular everyday mistakes that we see in our practice. I am going to try to get you some ethics credit at the end, so I will hit some stuff at the back.
And as you see from the title and the table of contents, if you've been flipping through the presentation, we're trying to hit 13 mistakes today in keeping with our Halloween theme, which means we're going to give you just enough information to be scared, but not quite enough to know all of the answers. So you're welcome. We'll also be giving you tricks and treats. So for each of these, we'll give you a trick, the horrible things that could happen, as well as a treat, a tip to hopefully help prevent those things from happening in your practice.
We've also come up with a 1 to 5 zombie rating scale. 1 zombie being the least scary and 5 zombies being the most horrible. But we know, as in all things, it depends on your company and the facts and circumstances on how bad any of these events could actually be for you. And so with that, let's get started with our first theme: forgetting to wear clothes to school, causes of generalized anxiety, public shame, and reputational harm. And I'll let Joanna take it away.
All right. So as securities lawyers, we tend to be on the OCD side. We try to keep things under control, keep things within the rules, and are fairly good typically at controlling our spaces. One area that can cause a lot of anxiety is where we intersect with the business teams, the IR teams that are much more focused on, selling, running the business, and less focused on very technical rules that we spend our nights thinking about. So Regulation FD, as a quick reminder, is a rule that says a company or person acting on its behalf, if they disclose material non-public information to certain market professionals, so think institutional investors, think analysts, the company must publicly disclose that information simultaneously if it's intentional disclosures. Think, the press release that you put out just before your analyst day that sets out the things you're planning to talk about, or promptly, immediately after you find out about a slip. This is the press release you put out after your executive goes off script in a Q&A session. So there's obviously a lot that can be said about Reg FD. A few specific areas we wanted to highlight were safe spaces and high-risk events for Reg FD. So the safe spaces are places where you're within normal business communications. So this is, commercial discussions. This is your professional advisors. This is transaction negotiations under an NDA. That's what you're thinking about here. This is safe from the need to disclose those communications, as well as properly announced earnings calls. So if you pre-announce an earnings call correctly, the call itself is Reg FD compliant. So you are less concerned about going off script in that context. The high risk events tend to be events that feel like a safe space, but in fact aren't. So for example, an industry conference, an analyst conference that may feel like an earnings call, but in fact isn't, because it does, either it wasn't properly announced, or it's a closed event, or other conditions, and a place where there's risk of going off script. One of the other high risk areas is social media, and Catherine will tell us some real horror stories there.
Well, I wanted to pass along two of my favorite Reg FD horror stories. One of them, this first, is pretty well known. And back in 2012, Netflix, the CEO of Netflix, posted on his personal Facebook account, this is personal, not the company account, and that Netflix had hit some streaming records recently for the month in June. And there was an immediate reaction in Netflix's stock price. The SEC sent a Wells notice to Netflix and the CEO indicating their intent to bring charges. Excuse me. Now, this was several years ago, and the SEC ended up withdrawing and not going after them, and letting them off the hook, and instead putting out social media guidance for public companies. So now everyone's on notice. If you have a CEO who strongly admires Elon Musk, keep them off Twitter or X. It's X now. That's our reminder. My second favorite Reg FD story is that of the CEO of Sharing Plow. Excuse me. Apparently, he walked into an analyst meeting so downtrodden that the analyst didn't take what he was saying at face value. And instead, one analyst noted that the CEO's downbeat demeanor was part of what caused the analyst downgrade. So it's more than just words here. It's presentation as well. And I think that's something we need to be clear with executives in their training. So what is so painful about Reg FD violations? That's our trick here. It's the scramble to decide if you have a Reg FD problem and have an NPI you need to disclose. And it's the decision sometimes to have to pre-release numbers or earnings that you would otherwise have waited to disclose. And there's also risk of enforcement actions. And because, this is something you can fix with a 24-hour disclosure, we're calling it a one zombie problem, but I'm curious what you think.
Yeah, I think it's if you catch it quick and it's something you can fix with a press release, you're probably in a one zombie problem, a little bit of embarrassment, frustration, but you can fix it. The times when it might escalate up to a 5 zombie problem or somewhere within that range is if it's something that's going to catch the SEC's attention, or something that created a pretty significant movement in the stock where there was definitely a disconnect or risk of insider trading.
Our treat or takeaway here: implement a Reg FD policy and a social media policy, and train your teams, train your executives, your IR team, and your legal team, and set procedures for your analyst communications, have a script beforehand. And I just wanted to note that in several of these Reg FD enforcement actions, the SEC declined to act against the company if the company cultivated an environment of compliance, so had a history of implementing policies and of training. So they'll go after the individual in that case, but leave the company alone.
The next nightmare we're going to talk about is one that you may not have thought to lose sleep over until this very moment. So I do apologize, but here you go. So you might have read the story last year about Barclays sort of accidentally issuing $17.7 billion of unregistered securities. Not a good look. So like most public companies, Barclays had a Form S-3 shelf registration statement under which they would issue various securities, and particularly a lot of debt securities. Because of a prior SEC violation, they had lost their WICSI, or well-known seasoned issuer status. And so therefore they had to file a Form S-3 rather than a Form S-3 automatically effective registration statement under which you would pay as you go. So the Form S-3 is required. You have to register a certain amount of securities, typically what you expect to use within the 3 years that the S3 is effective. So Barclays had a Form S3 on file. They had registered $20 billion of securities and were merrily selling securities. About $38 billion later, somebody discovered that, in fact, they had gone over the amount that they registered. So what that means from a technical perspective is that while they thought and represented that they had issued registered securities to investors, in fact, they had 17.7 billion of those were in fact unregistered. There's some pretty serious consequences in that situation, particularly the requirement to make a rescission offer to these investors. So Barclays had to go out, make a rescission offer to investors. At the same time, the SEC, they self-reported to the SEC. The SEC had limited sympathy for them, given that they had already, were well aware that they needed to file an S3 instead of an S3 ASR, and were clearly a sophisticated institution that should have been able to track their issuances. So Barclays agreed to a $361 million settlement. In connection with this event, they also had to restate their financial statements. Their stock price fell 10%, not a good place to be. Now, I think many of you are sitting here saying, I mean, we're not Barclays. We're like pretty small. We have either we have a Form S3 pay as you go, so we deal with this every time we issue securities, or we've got a pretty short line between the finance team that's issuing securities and the legal team. So this is a pretty low risk for us. Well, I'm going to try to bring it closer to home. The same rules apply to your Form S8. So Form S8, again, similar to the Form S3, registers only a specified number of securities. Typically, you'll put it in place. You'll put a pretty big number on there so you don't have to refresh it constantly. And then, of course, under your S8, you're sort of trickling out issuances over time, sometimes under multiple programs. You may be using third-party providers. And there's a risk, a possibility that you wake up one day like Barclays and discover that you have overissued under your Form S8. That's not a good place to be. So you are then in a situation where you either have to find another exemption under which you could have issued those securities, or you may have to do a rescission offer. You may have to put transfer restrictions on already issued securities, or you may need to bust resale trades. In any case, this is not the call you want to be making to your executive, to your director, or to others.
Agreed.
So what is our zombie ranking here?
Oh my gosh, rescission offers. I'm giving it 3 minimum.
Yeah, I think I'm there. I mean, if you're calling the SEC or you're calling your executives, it's not a good day. So the treat here is internal controls. Make sure that you know who is responsible for tracking usage under the Form S3 and your Form S8. If you use third-party providers, particularly for your Form S8, make sure that you are monitoring and having them report to you often. They may be counting not under the not with the S8 in mind, but rather, with the authorized shares or with other factors in mind. So make sure that you own and you know who owns those reporting. So back to Catherine for a few more general anxiety.
This is a generalized anxiety item. It's a pretty quick one. This is just your reminder, if you're an NYSE issuer, not NASDAQ, NYSE, that you owe the NYSE 10 days prior to your record date, a notice of your record date. And they're not particularly cooperative if you miss that 10-day deadline. Theoretically, moving a record date can cause a waterfall effect. You have a broker search, you have a mail date, you have a meeting date. So just avoid this problem entirely. We're giving it 1 zombie because it's pretty easy to remember, but in your annual meeting checklist, if you're an NYSE company, make sure this is in there. Make sure it gets done early. Don't wait till the last minute. And here's another one, and we were reminded of this because it's the year 2023. Say when on pay as opposed to say on pay is required to be held every 6 years, and it started in 2011. So 2011, 2017, 2023, we saw a bunch of these recently. And you're required to hold that vote every 6 years. And you're required to state in your 8K after your annual meeting what the board decided to do with respect to say on pay votes. So did the board decide to go every 1 year, every 2 years, or every 3 years? And you get 150 days past the meeting to get that disclosure on file. If you miss that 8K, we're probably losing S3 eligibility. You could also miss the vote itself. We've seen that happen as well. That could make SEC enforcement interested. We've seen a lot of plaintiff interest in proxies recently. At the very least, it's a disclosure controls issue. And then missing the Form 8K requirement can cause some angst with respect to S3 eligibility. There's a really easy solution to this. There's actually a proxy rule that requires that you state every year in your proxy when the next say when on pay is required to be held. So make sure that sentence is in there. And then theoretically, every year when you read through your proxy, you'll be like, oh, right, this is my year. Let's drop that in. So again, 2 zombie problem. It's usually catchable. Sometimes the plaintiff will catch you after you've mailed, but a reminder to keep an eye on that. So our next section is based around my own personal nightmare, the cockroach. It deals with regular run-of-the-mill items that jump up out of nowhere and get you and make you lose S3 eligibility. And we think they can generally be managed by regular application of pesticides or pest control, i.e. disclosure controls and procedures. So over to Joanna.
Yes, Form S3 eligibility. We talked about losing WIGSI status, but Form S3 eligibility is next level sadness for a public company. So Form S3 is a privilege, not a right. In order to gain that privilege, in addition to becoming a mature public company, so having filed for at least a year, you must have filed in a timely manner all reports required to be filed in the last 12 months. So that includes your annual reports, quarterly reports, and most categories of Form 8K. Typically, the default rule is you need to file 8Ks within 4 business days after the event. There are 2 unexpected cockroaches that I want to talk about here that could cause you to lose S3 eligibility in times that you might that are easy to miss. So the first one is the CEO and CFO certifications that are required on every annual and quarterly report. So these are truly boilerplate certifications. They're easy to prepare, but that means it's easy to make a simple error. And certain errors, if not corrected by the deadline for that report, could cause the whole report to be considered to be rendered late, even if you in fact filed it with everything that was required. And this is an area where your printer, your software could put you in a bad spot. So these are some errors that would cause you to file a corrected filing and make the periodic report late. So one is you're referring to the wrong document. You say 10K instead of 10Q. You have the wrong date. You have the wrong signatory. These are things that are easy to catch, but also easy to forget to check. And that's similar for the 906 certifications. So the trick here, we gave it 3 zombies because this is a terrible place to be. Anytime you lose S3 eligibility, it's a zombie, particularly if it's because of a filing you in fact made, but had a miss. So the treat here is to just double and triple check the certifications for each filing. That should be the last thing you check before you file, and the one thing you check after you file, just to make sure you didn't, inadvertently file the same one twice and miss one of them.
And just to be totally clear, if you omit one of these reports and pass the deadline, the whole report is late. If you make one of those little errors that we pointed out, the SEC has said you have to refile, but you'll be considered current. but we hate taking these calls. Clients hate calling us about this. The SEC has been so clear about what the consequences are for these. And clients kind of go into orbit when you say, I'm sorry, you lost S3 eligibility because your printer filed 2 CFO certs instead of a CEO and a CFO cert or something like that. So please check these before and after filing.
For sure. So the next cockroach we'll talk about is the one you were all expecting to see here, missed Form 8Ks. This is one we all have nightmares about. That's my main nightmare when I dream about clients doing things they didn't do and then not filing 8Ks for them. So good times. So the general rule, just quickly, is that for an 8K trigger, you must file the 8K within 4 business days after the event occurred. A few exceptions, but that's the general rule here. If you miss that 4-day cutoff, you're late, you lose S3 eligibility. Again, subject to a few exceptions. This slide shows the different categories of Form 8K. The ones highlighted in orange are ones that could cause you to lose S3 eligibility if you're late in your filing. Some of these are pretty hard to miss. So you're pretty unlikely to miss your 8K if you're going into bankruptcy. You're pretty unlikely to miss your 8K if you're being delisted. We have added zombies to 3 areas that we think are some of the worst cockroaches that you might find lurking behind your toaster. The one I want to highlight is under 502, related to D&O resignations. So as you know, there's often kind of fluid discussions around, is this director sticking around? Are they going to stand for re-election? Are there, movements, things we're doing? You could be in a situation where you get this email forwarded to you a week after the fact saying, oh, so-and-so has said he's not going to stand for re-election next year, or, has decided to resign. By the time you get it, it's too late. These are the kind of cockroaches we hate to see, and we try to mitigate by putting more formal notice provisions in place so that a more casual conversation, an email to the CFO won't trigger this without a formal notice. So these are ways we try to mitigate and add pest control for some of our cockroaches.
Adding pest control. Yeah, I want to highlight 2 other ones here that we've seen issues with in the past. One of them is amendments to your bylaws and amendments to your code of conduct or waivers of your code of conduct. Sometimes you make what you think of as very minor changes to your bylaws or your code of conduct. That can trigger an 8K. You can post code of conduct on your website if you have done appropriate disclosure in your 10K and proxy, but it is still subject to the 4 business day deadline. So you still have to get that posting done within 4 business days. Another one I've seen pop up for serial acquirers. So folks who buy small companies, maybe it's an immaterial bolt-on, it's not something you typically 8K, but you pay with stock. And you get caught up in item 302, unregistered sales of equity securities. Because you've paid in stock, if you hit the 1% threshold specified in that item, you owe an 8K, and if you don't file it, you lose S3 eligibility. So that is one to keep an eye on if you use stock consideration in small acquisitions, because you might not otherwise think the acquisition is material.
So we're still at 3 zombies here. S3 eligibility, 3 zombies, and the shame and disappointment that goes with that status. I think this is one where the 3 zombies can be a bit variable depending who you are. If you're a company that mostly issues, debt under 144A, you're not really in the equity markets, it may be 1 zombie. If you are a WIXI, you're about to do an offering the next day on a new S3 ASR that you were planning to file, this could be a 5 zombie situation.
Yeah, the other place I've seen this be an issue is for companies that use an at-the-market offering program. So they're continuously dribbling out securities throughout the year, and they need that capital infusion. So this can be a real problem for them as well.
So our next category is, I think, the most aptly named: evil clowns. Anytime the plaintiffs are sniffing around is not a good day.
It's not a good day. And how can we talk about the plaintiff's bar without talking about short swing liability? So as you guys all know, directors, officers, 10% stockholders may not buy or sell securities, make a profit without disgorging that profit back to the company, repaying it back to the company. This is a strict liability statute. Knowledge and intent do not matter. It's enforced on the individual. A very active plaintiff's bar makes their living on enforcing Section 16. And if you have a profitable trade within the 6-month window, you can expect a demand letter from one or many plaintiffs demanding that the company enforce the disgorgement and then pay over some percentage of that disgorgement, usually a hefty percent, to the plaintiff for their services. And there are, of course, exemptions. And this is such a technical area that I just wanted to highlight a couple spots. One is household trading. So any family member who lives in your household, immediate family member who lives in your household, gets picked up in your reporting and in your short swing liability. If you are a CEO of a public company and you have a teenager who has access to the Robinhood app and considers themselves a day trader, you need to have a very serious conversation about trading in the securities of your employer. Because technically, all of that day trading that they do all day would get picked up in your Form 4s. It'd be a horrible situation to be in. Another area to watch out for is estate planning. Often directors and officers have very complex estate planning vehicles, family LLCs or LPs, trusts, and changes in the officers or the members or the trustees of those entities can affect your Form 4 reporting, and transfers between those entities we've seen trigger a purchase or a sale under Section 16. So the lesson here, and I'll skip to the treat, is have a really strong pre-clearance checklist, educate your executives and your directors and your large stockholders that any movement in their stock must be pre-cleared in advance. And I give this a 4 zombie problem, mostly because as in-house legal, you're probably going to an executive or a director and telling them to cut you a check. At the same time, you're having to deal with the plaintiffs emailing you all day. So it's just a really unpleasant situation to be in. And then you also may have to pay outside law firms to help you clear the problem. So just kind of unpleasant all around. Our second area of plaintiff's bar area of interest is something we've seen pick up in recent years. The plaintiffs' firms are very interested in proxy disclosure, in particular vote counting and voting standard disclosure. When you put out a proxy statement and you ask for a vote, you're required to explain the vote needed to approve that proposal. And that can come from several sources. It's in your charter and bylaws, probably. The state law, the DGCL, requires certain vote thresholds to pass certain proposals. NYSE and NASDAQ require a votes cast level of voting standard on anything they require to be approved. So LTIPs would be an example of that. And so you're going to state law, you're going to all these sources, and then you're going to your proxy and describing what each vote means under that standard. So yes always means yes, and no always means no. But abstain might mean no, or it might mean nothing and have no effect, depending on the standard. And then you have this thing called a broker non-vote, which is what happens when a broker can't submit a vote on behalf of a retail holder because they didn't give them direction. And that only applies on certain non-routine matters. So, because we need to make sure that people are still alive who are working from home and listening today, we have 2 fun questions for you. Here are your 2 questions, and I'll take a show of hands in the room. This first standard is a majority in voting power of the shares present in person or represented by proxy and entitled to vote on the matter. Who thinks that abstentions and broker non-votes have no effect at all? Who thinks the answer is B, they're both votes against? Who thinks that abstentions are against and broker non-votes have no effect? Who thinks broker non-votes have, I think, have no effect, or have effect is against, and abstentions have no effect? And who has no idea? All right, let's see what we have online. I'll read it out. Looks like the majority at 29, no, the majority are E, 34% have no idea. After that, I've seen most folks answer 30% at abstentions have the same effect as against. So that would be item C, and that is the correct answer. Broker votes have no effect. They are not considered entitled to vote on the matter. Abstentions have the same effect as a vote against. Abstentions are essentially a no vote for purposes of this voting standard. This is what we call like the Delaware standard. It's the kind of default that you head into. Lots of companies use this in their bylaws for general voting. Okay, here's the other one. Notice, only a few words are different. A majority in voting power of the shares present in person or represented by proxy and entitled to vote thereat. Thereat means at the meeting. Who thinks it's option A? Who thinks it's option B? I got one for option B. Who thinks it's option C? D? And E, I have no idea. Thank you. Okay, all right, let's see what we have online as well. Majority, again, at 41% at I have no idea. And then otherwise evenly split between both count as against, and then the same as last time. Abstention are against and brokers have no effect. The answer for this one is B. This is a majority of the quorum standard. That means a majority of the shares that showed up at the meeting and voted. So you've got to have more yeses than noes, abstentions, or broker non-votes. But this is just a word, right? And sometimes if you see that thereat via thereon, it changes the meaning of this whole sentence. So what do we have to say about this? Oops, I got to click out of this.
I have one thing to say.
What?
Never copy and paste.
Never copy and paste. Do not copy and paste your voting standard from the prior year. You should always go straight to the source, to your charter, bylaws, Delaware law, or the standard at the NYSE, and pull that language directly into your proxy so everyone reading it knows exactly what we're dealing with.
The more fun copy and paste, it's from the precedent.
Oh yeah, no copy and pasting from precedent. And then the other thing is get multiple sets of eyes on this. I think this is the hardest standard, the hardest thing to do in a proxy, particularly if you have a novel proposal and it's not one of your usual ones. Phone a friend, get some more eyes on it, and have folks look at it. The tricks here, we've seen lots of plaintiffs' firms and send in demand letters after proxies have been mailed. That means you've got to supplement your proxy to deal with the problem and pay them a fee for their services. If you theoretically were to discover this after you held your vote, and then you're not really sure if your proposal passed, that would be also a very bad situation. So we gave this 3 zombies, hoping you can fix it. Yes, sir.
There are cases in Delaware where Delaware has invalidated the vote because the voting standard was improperly disclosed.
So one of our V&E partners has noted that there have been times in Delaware where they have invalidated the vote because the voting standard has been improperly described. So there's your nightmare.
I feel like proxies are always nightmares.
And from here, I pass things to Joanna, who will cover monsters under the bed, enforcement areas of interest.
Another very aptly named category. And the ones you don't want lurking around. The first one, I think, for myself, I was a bit confused why related party transaction disclosure hit the 9th level of securities law nightmares, until you learn the fact that the SEC is laser focused on it right now. And when the SEC is laser focused, it means it might be lurking under the bed. So just at a high level, the slide outlines the rule for related party transaction disclosure, but essentially in your 10K or your proxy statement every year, you need to disclose transactions in which the company was a party and a related person was a party. And the related in an amount that exceeds $120,000. Some of these are, very straightforward, but then there's a few around the edges that can get you in a bad place. So I'm going to tell two stories from very recent SEC enforcement action. So September of this year. So the first one was Lyft, where Lyft was fined $10 million for not disclosing a director's role in a private sale of approximately 424 million shares in connection with Lyft's IPO. While Lyft was aware of the trade, they were not aware that one of their directors was receiving millions of dollars of compensation in connection with setting up this trade. So it was never disclosed in the filings related to the IPO or in the subsequent 10K. The second one is an interesting one. So several siblings had worked together at a company for many years. Over the course of time, one of these siblings was promoted to an executive officer position. They carried on with their lives and their jobs. And the other siblings who weren't officers had compensation over $120,000. Several years later, the SEC comes back and says, hey, what's with this disclosure? We're missing all of the disclosure about these siblings who are receiving over $120,000 from the company every year in compensation. This is one where it looks like a relatively low penalty, $500,000. It seems likely that we have now all been put on notice, and that number will look different in subsequent years for those of us who have now been put on notice. So the trick here, potential enforcement action, if the SEC enforcement is around, not a good day. The treat here is to really focus on D&O questionnaires. Make sure that your directors and officers are really thinking about related parties. You want the D&O questionnaires to be over responsive so that you'll see lots of things flagged that you can look at and say, yes, this doesn't meet the disclosure thresholds for related parties. If you're not getting anything that is over reporting, it may be time for a refresher to remind your directors and officers of the risks as well as the recent enforcement, so that they're thinking kind of to the second and third degrees of separation areas that might trigger this disclosure.
All right, section 16, returns. So, again, we've talked about section 16 before. You owe directors, executive officers, greater than 10% holders, owe forms 3, 4, and 5. Form 4 is due within 2 business days of a purchase or sale, grant, award, vesting, et cetera, et cetera. 2 business days is kind of short. We see folks be late, miss these, forget to pre-clear, do some sort of complicated estate planning transaction that they don't realize until after the fact, hits the rules. So I would say most public companies at one time or another have to put disclosure in their proxy under item 405, self-reporting a violation of section 16, that it's late or missing, right? Historically, I'd call that a one zombie problem because it was pretty widespread. We didn't see a lot of enforcement until September 27, 2023, earlier this year. The SEC has said they have an ongoing enforcement sweep. So this is just round 1. And they were looking at proxy and 10K disclosure and noticing either lots of late filings or some missing filings. And they've settled here between 1 and 200 grand with a number of individuals and companies. So like I said, the trick is item 405 disclosure. I would not have called that a 3 zombie problem until this enforcement interest. The reminder, as always, is a strong pre-clearance checklist and training of your executive officers and directors. All right, insider trading. I told you I'd get you some ethics credit. Here we go. So most of us here are familiar with the general rules of insider trading, transacting in securities in breach of a duty while possessing material non-public information with knowledge or recklessness. Great. There are certain affirmative defenses, including 10b5-1 plans. You guys should remember those rules recently changed. We're not going to go into those now, but make sure you comply with them if you do want the benefit of that affirmative defense. But there have been some really great 10b5 horror or insider trading horror stories, particularly with the COVID pandemic, where significant others of lawyers who were hanging out while they were working from home learned some interesting non-public information and traded on it. But like I said, that's not what we're going with today. I'm passing it over to Joanna.
The real nightmare here is when your best laid plans, your very conservative policies, everything you've done to do everything right has in fact put you in a worse position with SEC enforcement than you were to begin with. Shadow insider trading. So many of you have probably heard, or some of you may have already heard the story about the Panawat case. In Panawat, and it's described on the slide, so I'll just summarize it. So Panawat was an employee of a biotech company. He, worked at the biotech company. In the course of his employment, he learned that his company was merging with another company. In his great wisdom, he concluded that such a merger would probably have a generally positive effect on the biotech industry. So he went and purchased call options of a third biotech company, not related to the transaction at all, and made a reasonable profit of $107,000. Good down payment on a mortgage in some cities, probably not California, but anyway, he made a few bucks, right? The SEC got wind of this and came around looking. This is one where this doesn't fit the technical insider trading rules. So he didn't trade on either of the companies involved in that transaction. We're not aware that there was an NDA that he violated in this case. However, his own company's insider trading policy said that in addition to not trading on, your company's stock or kind of counterparty stock, it had this broad provision that said you can't use the information that you've received through your work to trade in securities of another publicly traded company. Very broad, designed to be protective, but the SEC tapped into that and said, look, you had this policy and you clearly used information that you gained in your work to purchase shares of another company, and has brought enforcement action based on that policy. This is a nightmare. This is a nightmare when you do everything right and it turns out you get punished for it.
Not that Panawat was doing everything right, but the company was.
The company, yes.
Yeah, and we've gone back and forth on the rate. I would say insider trading generally is always a 5 zombie problem.
Yes.
Yeah. But in this case, the SEC pursuing novel arguments for insider trading liability makes it a bigger problem. And we've had a lot of clients give us a call to review their insider trading policies given this Panawat case and take a look at what is appropriate for those companies.
Yeah, and that goes to our treat. It's a good time in light of both the new insider or the updated insider trading and 10b5-1 rules, as well as this case, to take a fresh look at your insider trading policies, take a fresh look at your 10b5-1 plans and policies, check in with your favorite securities lawyer and just make sure that you have a well-targeted policy that isn't increasing liability rather than decreasing it for yourself and your employees.
Yeah. All right, restatements. Restatements are kind of a nightmare because as securities lawyers, there's not much we can do to prevent them. We're stuck in a position where we have to react to them. And usually we have to react to them very quickly, 2 days before a 10Q or a 10K is due, because something has come up and we need to sit and make a determination, help make a determination on the materiality of the problem, whatever it may be. There are many causes of restatement, but
although occasionally, as we learned with Barclays, the cause can be a securities law issue.
that is true. That is true. So avoid those. Avoid selling 17.8 billion in unregistered securities. One of the first things that lawyers are going to be asked to do when there's a restatement issue is to help determine whether it's a big R restatement or a little r restatement, or if they're have decided there will be no restatement. But let's focus on big R and little r. Big R restatement is that there are errors in previously issued financial statements such that you have to go back and reissue them. That was almost always going to mean late filings. And potentially withdrawal of reliance on prior financials. Revision restatements or little r restatements are restatements where it's determined you can recast that past information in current and future reports. Sometimes that will also involve late periodic reports. So these are the many tricks here. One is that the NYSE and NASDAQ have set rules that companies must adopt written policies to claw back erroneously awarded executive comp to current and former Section 16 officers in the event of a big R or a little r restatement. So once you've determined that one of these exists, you're also having to look at your clawback policy. Second problem is that both big R and little r restatements can cause late periodic reports. That puts you back in S3 land. It maybe makes Rule 140, 144 unavailable, very unpleasant for all. Finally, enforcement's really interested in this. In 2022, they brought 12% of all of their actions by enforcement were related to company reporting and audit and accounting matters. So this is where internal investigation can trigger internal investigations. The SEC has I consistently identified restatements as an area of interest. So 5 zombie problem, almost all tricks. I don't really have a treat for you other than a reminder to get your clawback policy put in place by December 1st, pursuant to the deadline, and to wish you good luck. All right, our last section today, again, because I promised you ethics credit, which is the call is coming from inside the house, part 205. Here we go. This is our last scare. We tried to get to the scariest thing last. So we wanted to remind all of you who are lawyers today getting CLE credit that under Sarbanes-Oxley, there was passed this part 205 provision that created, it's sometimes called the up the ladder rule. And it created a mandatory obligation for attorneys appearing and practicing before the SEC to report up the ladder if they become aware of evidence of a material violation. So we'll hit all of those areas. So what does up the ladder mean, or reporting up the ladder? That means first you go to your chief legal officer. If they do not address adequately your concerns, you go to the audit committee or another independent board committee. And then from there, you go to the full board, right? So this is an internal report process, and it is mandatory that you do so. All right. So who is subject to this? What does appearing and practicing before the SEC mean? It probably means most attorneys on this call. It picks up law firm attorneys who are advising clients. It picks up internal legal if you advise on the content of an SEC report. That's fairly wide. It would include supervisors, in particular the chief legal officer, the GC position. And so you don't have to consider yourself a securities lawyer to be considered to be appearing and practicing before the SEC. They really cast a wide net here. So, most folks advising on SEC reports will get picked up. So evidence is credible evidence based upon which it would be unreasonable under the circumstances for a prudent and competent attorney, which I consider myself.
We hope to be.
Yeah.
We aspire.
Not to conclude that it is reasonably likely that a material violation has occurred, is ongoing, or is about to occur. A material violation would be a material violation of the securities laws, a breach of a fiduciary duty, or a similar material violation. And covered violation would be those by the company or officer, director, employees, and agents. So widespread here, right? So there are my zombies. So violations of Part 205 subject attorneys to civil but not criminal liability and penalties and remedies. That would mean fines, but that would also mean you are no longer allowed to practice in front of the SEC. So we're talking not job loss, but career loss. The real danger here is not reporting up, as unpleasant as that would be to have that conversation internally. The real danger is being second guessed because you didn't report up. That's the scenario you don't want to be caught up in at your company. And I will cut you a break. It has never been enforced. So since it was passed, knock on wood, we haven't seen it. However, in a speech last year, so in 2022, Commissioner Lee did reference Part 205 and indicate an interest in giving it a test drive and potentially implementing other stronger requirements for SEC or for attorneys who practice or appear in front of the SEC. So we've put it here as our horde of zombies, as you can see. And our treat here is just to remind you that you should have procedures in place internally to formalize this process and be familiar with them, know what they are, educate your internal legal team about them, and then hope for the best.
Yeah, I mean, you want to think about it in relation to your whistleblower policies as well, right? So if there's a non-legal whistleblower that's bringing up issues and the SEC then learns about them through that, that's another situation where you could be second guessed for not raising something. Mm-hmm. But certainly materiality analysis is always a challenge, knowing what needs to be escalated and what doesn't.
Well, and with that, we have reached the end of all of our nightmares. We hope we have left you with something to worry about.
So many nightmares.
And thank you for joining us.
Yes. Curious if there's any questions that either the group has here or if anything's come in online. Not seeing any. Well, thank you all for joining us on a Friday the 13th. I will give you one extra tidbit. It is not only Friday the 13th, it is also Catherine's birthday on Friday the 13th.
It's a lucky day.
It's a lucky day. So this is a good time. Hopefully we have duly scared you and gotten you into the Halloween spirit.
Have a good rest of your day.